Okay, let's have a look at the new continuing competence regime, which is, as we know, replacing the old 16 hours inputs-based model of the CPD regime we've had for 30 plus years. And indeed, some watching this video may already have opted in. The opt-in period is now live, has been live since the 1st of April, and there is a guillotine period or guillotine date on the 1st of November 2016 where implementation becomes compulsory. So we're at a point where I think firms are well advised to take some time to really think through what they're doing. There are some potential tripwires, if not bear traps, in the new regime, and I hope to uncover some of them for you in this set of presentations. I say set of presentations because rather than doing one very long talk, I thought I would break it up into 6 component parts dealing with some key areas, and those are the ones set out there. The competence statement is a key new piece of kit that we haven't seen before. We need to get our heads around that. The continuing competence toolkit is a key new resource which the SRA has published and is on its website. We need to have a think about what it says. The annual declaration linked to the practicing certificate renewal exercise is very important in terms of understanding the language of that declaration and how that might inform lawyer behaviour and what they are happy and prepared to sign off, or what you are prepared to sign off on their behalf on the PCRE. Systems and structures. You will want to be sure that the systems and structures that you have are fit for purpose and identify potential gaps and areas for improvement and tightening up. Challenges and concerns. There are various of these, and the challenges and concerns that I will focus on have been drawn from feedback and conversations from the sector, so I will focus, I hope, very much in on what people are actually worried about, before finally unpicking this old chestnut of reflection being a good idea, because it's a truism to say that reflection is a good thing, but hitherto we've not really spent very much time thinking about why that might be. And there's some new research coming out of the Harvard Business School which suggests that actually we ought to take a moment to think about some of these benefits. So I'll deal with that in my last video. Okay, so let's have a look at the competence statement. There are at least 3 sort of key questions, I think, that arise under this heading. One is, how do we interpret it? How are solicitors expected to engage with it in practice? What does that look like? And also, if we are a firm with our own competency framework, what does that mean in terms of mapping? Is that what we should be doing or not? And we'll take each of these issues in turn. How do we interpret the competence statement? I'm assuming that you may have a copy of the competence statement in front of you as you listen to this. If not, it might be an appropriate point to pause the video and get a copy of it. I'm not going to go through it blow by blow. That would be tedious and time consuming. What I want to focus in on really are the broad sort of concepts in terms of interpretation, and also perhaps picking some examples from the competence statement to illustrate those key principles. The big thing to be aware of, I think, is that the competence statement in and of itself does not really say very much about levels. It doesn't really mean very much to a particular lawyer when read at face value. It only means anything when an individual solicitor looks at the competence statement, reflects on it, and asks questions around his or her own practice and what the competence statement means for them as individual practitioners. And you know, that's actually less about practice area, because what you'll notice is there are some areas which are practice specific. I'll pick up on those, but there aren't very many. The competence statement is a generic skills-based, competency-based framework. It's really very much to do with seniority and role. So in other words, if you have an NQ will read and interpret the competence statement in a very different way to a senior partner, a head of department. So we have to keep that in mind, and I'll bring some examples hopefully to demonstrate that. And it also relates to job role. So the idea really with the competence statement is that, as we know, not all solicitors actually do the same job in practice, and some solicitors are pure technicians, some solicitors are managers, some solicitors are given certain responsibilities which may be client facing, which other solicitors just aren't given in practice. So seniority, role, and to a degree practice area are crucial in interpreting the competence statement correctly and contextually. I'll come back to it. What I want to sort of just get rid of, if you like, are any misconceptions around the threshold standard and the statement of legal knowledge, because the SRA, I think, contributed to a certain amount of confusion in the market by publishing the competence statement seemingly as part of a suite of documents which included the so-called threshold statement, the threshold standard rather, and the statement of legal knowledge. Very briefly, those two documents are red herrings when it comes to interpreting the competence statement for qualified practitioners. The threshold statement and statement of legal knowledge will become incredibly important as the SRA begins its substantive work on redefining the pre-qualification training and assessment regime. The threshold standard will be worked up to be, if you like, a benchmark document which identifies the level at which entrants to the profession at the point of admission need to be operating. But we're not there yet, and we probably won't be there until 2018, 2019. The SRA will begin its substantive piece of work. It's already begun its substantive piece of work in this regard, but its formal consultation is not due until the winter. And the statement of legal knowledge is, again, something which is very, very relevant to that piece of work, because whatever training and qualification regime the SRA comes up with, the SRA needs to make sure that it maps against the core statement of legal knowledge, the knowledge areas that all solicitors at the point of admission need to be able to demonstrate they know something about at the suitable level. But for our purposes, for CPD, post-qualification, let's not get confused, they are not relevant. Okay, let's go back to the competence statement. So if we just pick some examples, we have competence grouping A, which is ethics and professionalism and judgment. I mean, arguably, these aren't so much competencies as such as principles, and actually, certainly in respect of areas like A1, acting honestly and with integrity, competence, it seems to me, is proven in the negative, by the absence of questionable behaviour, rather than lawyers evidencing that they proactively act honestly. A2, I think, is worth pausing on, because A2 is the competence most clearly connected with undertaking continuing professional development. So if we think about it, the SRA is debunking the idea that good CPD is about how many hours you do, and instead is trying to position CPD as an activity which is to do with maintaining competence and requisite legal knowledge. So this competency A2 plus the behaviours suggested in the toolkit are worth considering, it seems to me, particularly if you are responsible for learning development at your firm. A4 in terms of legal knowledge, that's very much about the individual lawyer. Effectively, lawyers have to make sure that they continue to know what they need to know, but they also have to know enough around the edges of their practice that they know what they don't know, if that makes sense. So in other words, if you're a capital markets lawyer, clearly you don't need to know about wills and probate, but if your client comes to you and says, will you do my will, you have to have the self-awareness that says, no, actually I can't do your will because I don't know the first thing about it. So A4 is actually pretty straightforward, it seems to me. In terms of some of the other areas, B5 within technical legal practice, undertaking effective spoken and written advocacy. Advocacy here, note, has a generic meaning in terms of the skills required to effectively articulate the client's position or interests. It is not litigation specific. It is not advocacy in that sense, so it applies equally, for example, to a commercial lawyer who, let's say, is influencing a completion meeting in his or her client's favour, as it is about a stand-up tribunal advocate doing his or her thing in court. So note that. And there are various other competencies which really drill home this idea that whilst on some level they apply to all practitioners, actually in terms of how we interpret them, it all boils down to seniority and role. So, for example, within grouping C, working with other people, establishing and maintaining effective professional relations with clients in C2, again, in principle applies to all solicitors, but depending upon the firm's client access and matter management protocols, some or all of the sub-competencies within C2 may actually not apply to junior solicitors, for example, at all. Likewise, establishing and maintaining effective and professional relations with other people within C3, very much to do with seniority. So sub-competency C3.2, delegation, C3.3, supervision, clearly will not apply to some lawyers at the more junior end. And another example of the theme perhaps is within D, managing yourself and your own work. Within D3 there are some competencies around applying good business practice, and there are some sub-competencies around costs and billing, and applying rules of professional conduct to accounting and financial matters, which again will be very, very driven by issues around experience, seniority and role. So really there is an unpicking exercise for all solicitors to do, and ultimately for line managers to be mindful of, in terms of, well, what are the competencies that are relevant to this individual that I'm talking to. Okay, that's enough, I think, in terms of how we go about interpreting the competence statement. Not necessarily very straightforward, but let's talk about rather how solicitors are expected to engage with it in terms of frequency and depth. There is this concept in the toolkit, in the SRA Continuing Competence toolkit, that there is something that there is something around scheduled engagement which is important here, and scheduled engagement probably looks like learning development reviews. For example, those interactions designed to help a lawyer put together their development plan, which may or may not be folded into the appraisal process, mid-year, end of year. And at the very least, and certainly on the current annual declaration wording, at the very least lawyers will need to consider the competence statement once a year when it comes to annual declaration time. So it's going to be, it seems to be, up to the firm to decide what scheduled engagement should look like for them and for their particular lawyers. In terms of mapping, lots of questions and observations here. If you don't have a competency framework, there's nothing to map. The competence statement effectively will become your de facto competency framework, and some firms may find that actually a bit of a bonus on the part of the SRA. Will it work if you try and map it against your own existing competencies? Well, I suppose the obvious point is you won't know until you try. The feedback coming through from practice is that actually, mapping is taking a bit of time. There are lots of commonalities, but there are certain things perhaps which aren't particularly explicit in a firm's competency framework, which are very explicit in the competence statement, not least of which the ethics type considerations, for example. Mapping, I think, should also be considered and revisited when we know exactly what the annual declaration is going to say, because the reason I say that is that if the annual declaration is very explicit in relation to what it is suggesting in its wording that lawyers will have done, then it's possible that that a mapping might actually hide the competence statement behind the firm's own competency framework. So in other words, if at annual declaration time a solicitor is explicitly asked to sign off that they have considered the competence statement, but actually up until that point they've never seen it, that might create some issues. And that might be as much an education and information issue as it is a mapping issue. So visibility and clarity. The alternative is to work with both. So one interpretation might be that actually conversations around performance reviews should focus on the competence framework of the firm first and foremost, with perhaps the SRA competence statement appended somewhere in the documentation and in the process as a belt and braces or wash-up type safety measure, if you like, if nothing else, to facilitate a smooth annual declaration and PCRE process. And we'll come back to annual declaration in one of our later videos. One question as well which I've introduced here is mapping your L&D program against the competence statement. Probably a good idea in terms of identifying strategic gaps, but a point to note here is that I think firms should resist falling into the trap of mapping their training programs at the entity and cohort level only, and saying in effect, well, look, as long as we provide training that covers broadly all the competence statements at an appropriate all the elements within the competence statement rather at an appropriate level, that will be enough. Because actually the new regime at its heart assumes a greater focus on identifying learning development needs at the individual level. In other words, if you can provide all the training in the world to lawyers at a particular level in your organization, but it may not necessarily identify and address the specific learning and development needs of that particular lawyer. So that's something that I think firms need to be mindful of. Okay, that completes what we need to talk about for the time being on the competence statement. We'll take a break now and start again in relation to the Continuing Competence Toolkit.